podcast published by the EMEA Employment Group. Periodically, members of our practice group get together to discuss interesting and topical cross-border issues. Meritas is a global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam Murray-Hinde, a lawyer and partner at the law firm Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today, I'm joined by Mandy Armstrong from Andersen Strathern in Scotland and by Kato Aerts from Lydian in Belgium. Both are employment lawyers and specialists. And our discussion topic today is neurodiversity. A good place to start is by looking at what neurodiversity means, and this is a term used to describe those people whose brains function and process information in a slightly different way. This includes conditions ranging from dyslexia, autism, ADHD, to name but a few. The UK's NHS estimates that 1 in 7 people are neurodivergent. I saw a recent study by Zurich UK, which published some interesting stats that I wanted to flag here. And this basically said that 63% of neurodivergent workers believe that employers view neurodiversity as a red flag. And nearly half, so around 47% of neurodivergent adults said that they hide their conditions from prospective employers, and that 51% have failed to disclose their conditions. And this is highly relevant given that a lot of employers' obligations are based on it having actual or constructive knowledge of someone's disability. Although, as we know, for indirect discrimination claims, this is not required. So employers need to be careful about the impact of general practices and policies. Now, the stats in relation to recruitment aren't good either. 31% said their application had not been taken further once they disclosed their condition, while 28% said they were rejected on subjective grounds relating to their communication style or the team fit. Worryingly, just over half believe that recruitment processes are aimed to weed out neurodivergent candidates instead of assessing abilities. This is an increasingly important area for employers to get to grips with. And after those stats, I wanted to try and inject some positivity. And I was reading an article in the Financial Times here in the UK at the end of December, which reported that UK employers were waking up to this competitive advantage of hiring neurodiverse people. But there's clearly still a lot that we need to do to improve labour market access as the employment rates remain low. Now, turning to my guest today, Kato, I wondered if I could ask you first to comment on why neurodiversity is such a crucial topic for the modern workplace.
Sure. Well, in terms of employment, neurodiversity is often referred to within the context of recognizing and respecting differences, fostering environments where a neurodivergent individual can thrive, and ensuring that rights are protected under the applicable legal framework. The topic is specifically important because neurodivergent people can bring strengths and perspectives that can drive innovation and success within a company that are often still overlooked. And additionally, these strengths can only be expressed if workplaces are designed to support them. And that's where it often still goes wrong. Many organizations still aren't fully designed to support neurodivergent employees. Biases and traditional structures, processes, and expectations often lead to a narrow definition of productivity and success, leaving behind individuals who think or work differently. And this is especially relevant in economies like Belgium, where the inactivity rate remains quite high compared to other European countries. So, although this is obviously not the only solution, supporting neurodivergent individuals not only builds a more inclusive labor market, but could also help reduce unemployment rates or perhaps even reduce long-term illness by avoiding things such as neurodivergent burnouts. So in short, fostering and supporting neurodiversity isn't just a social responsibility. It's a smart strategy for building a stronger workforce.
Thanks, Kato. And Mandy, why do you think it's becoming more of a topical issue for employers, specifically in Scotland and the UK?
Yeah, so I think we're dealing with, it's becoming more of a topical issue for employers because as a society, I think we're becoming much more aware of and more accepting of the fact that we are not all the same. Again, at a societal level, I think there has been a shift away from the idea that there is something called normal and that people who don't comply with normal need to do something different in order to comply with a particular mould. when we think about in the not so distant past, conditions like autism were treated as mental illnesses. We were institutionalizing people with conditions like autism. We were looking at how to treat those conditions as a medical illness. And of course, we're miles away from that now. But in terms of our workplaces, I think we really are still on a journey in terms of understanding what neurodiversity is and how we ought to be supporting neurodiverse employees at work. And I think, Sam, the statistics that you highlighted at the start really show that we are still on that journey. I think the other reason why neurodiversity is becoming such a topical issue in workplaces is in relation to education and schooling. As well as employment work, I do some work in relation to additional support needs. So that's really looking at adjustments and supports for children in school, and placing requests for children in school who have additional support needs like neurodivergent conditions. And what we're seeing there is a huge surge in the numbers of children and young people who are being diagnosed with additional support needs. And that includes things like, autism, ADHD, dyspraxia, dyslexia, and so on. And that increase in the numbers of children being diagnosed places pressure on schools to recognise and to support those young people. And because of that change in the education sector, and because of things like a presumption in favour of schooling these children in mainstream education rather than placing them into specialist provisions, we then see a resulting impact on the workplace, because those children move through the education system, they move on to college, they move on to university, or they move into the world of work. And so I think what we've seen is that within the education sector in the UK, the education sector has become much better equipped to deal with and to support neurodivergent children. But our workforces then need to also take that on board and also need to become better equipped.
Yeah, I think that's a really interesting point that often isn't picked up on, about that transition from schooling and the education through to the workplace and keeping people employed and making use of their skills. And I think that kind of plays into some of the sort of cases that I work on, where you have to be careful not to stereotype, because the cognitive abilities can vary vastly between individuals, even when they have the same diagnoses. So there's a real need for employers to be getting medical advice to be able to specifically help those people in the workplace. So moving on to a slightly different angle, Mandy, I wondered if you could sort of comment on the main risk areas that you see for employers at the moment.
Yes, so in terms of risk, from a strictly legal perspective, the main area of risk is in relation to discrimination complaints. So as you'll know, the Equality Act 2010, that's the legislation that prohibits unlawful discrimination in the UK, and it does so on the basis of certain protected characteristics. Neurodivergency of itself, or neurodiversity, is not a protected characteristic, but disability is. And the definition of disability in the 2010 Act is wide and is potentially far-reaching. So an individual is disabled in terms of the Act if they have a mental or physical impairment which has a substantial adverse effect on their ability to carry out day-to-day activities. And as you'll know, that means that it's possible for conditions that we might not think of in a kind of day-to-day context as amounting to disabilities to nonetheless be classed as disabilities in terms of the Act. So I've had cases in the past where individuals have been able to establish that things like migraines are disabilities, and we might not think that in a sort of day-to-day context. It means in the context of neurodiversity, it's possible for an individual to meet the definition where there is a substantial adverse impact on their day-to-day activities. So, for example, a condition like autism may well meet the definition. A condition like ADHD may well meet the definition. It's not a one-size-fits-all approach, obviously, and it's all about looking at the individual specifically and how the condition affects them specifically. And so assuming that the individual can meet that definition, then there is a risk there in terms of discrimination complaints if that individual is treated less favourably, is treated unfavourably by their employer for reasons related to that disability. And the employer is, of course, under various duties, in particular the duty to make reasonable adjustments for that individual at work. I also think, though, when we look at risk in the context of neurodiversity, that it's important to consider that there's a wider risk than just a strictly legal risk, because I think there's a risk for employers in potentially excluding a huge pool of talent from their business if they are not focused on really understanding what neurodiversity is and understanding how to create a more neurodiverse workforce and a more inclusive workforce. We all know the benefits of having a diverse workforce, of having people from different walks of life, people with different perspectives, people with different experiences, and of course people who have different strengths. And good employers and good managers are able to build teams that are focused on individuals' areas of strength and that allow people to grow and to develop those areas of strength. And so just in really generalist terms, somebody with autism might well find the social situations difficult, but they might be very good at analytical work. Or someone with something like dyslexia, they might need written work to be checked or approved, but they might be an excellent verbal communicator. They might be that person who's really good at holding difficult conversations, or that person who's really good at standing up and giving presentations. And so I think the risk for employers who are not interested in knowing more about diversity, who are not interested in looking at how to create a more inclusive culture, is really that they're potentially cutting out a huge talent pool.
Yeah, I think I've spoken at some forums before where we've had disability charities present, and I have to say that a lot of employers can view these obligations under the Equality Act as being a burden. And more of a kind of checklist that they have to go through before they make a determination on something, rather than being a tool to help them resolve a situation and to get the best out of that employee for both the company and that employee. And those some minor adjustments, which actually don't cost much in practice, can really pay off and really be beneficial. So we need to see a bit of a mindset change, I think. One of the benefits of the Meritas network is having this ability to compare jurisdictions. So I was going to turn back to Kato and just ask you about the legal framework in Belgium around the inclusion in the workplace, specifically for those who are neurodivergent.
Well, very similarly as in the UK, so Belgium has established a legal framework that can serve to promote the integration and inclusion of neurodiverse people in the workplace. And this framework has, of course, been strongly influenced by international and European standards, like the European Employment Equality Directive. And the core legal basis of the Belgian framework is the Belgian Anti-Discrimination Act of 2007. And this act provides for a number of protected criteria, such as gender, religion, age, sexual orientation, which means that discrimination on one of these grounds or several of these grounds is prohibited. And one of these criteria is disability. And then, of course, as Mandy already mentioned, one can ask the question whether neurodiverse people and neurodivergent traits can be considered a disability within the context of the law. And for a very long time, the term disability has been viewed almost exclusively as an individual medical problem. But in recent decades, the approach has been questioned. So today, we no longer look at only the individual level, but also how an environment does not adapt to certain characteristics of that person. For example, the UN Convention on the Rights of Persons with Disabilities defines persons with disabilities as persons with long-term physical, mental, intellectual, or sensory impairments that, in interaction with various barriers, can prevent them from participating fully, effectively, and equally with others in the society. So Belgian anti-discrimination law itself does not include a definition of the term disability, but the European Court of Justice has already ruled on how to interpret the concept of disability. And already in 2006, the court ruled that the term disability within the meaning of the European directive must be understood as a limitation resulting, inter alia, from a physical, mental, or psychological impairment which hinders the participation of the person concerned in professional life. And given that the court also speaks of a mental disorder, neurodiverse persons could certainly qualify as having a disability, depending, of course, on the circumstances. And if that is the case, these people should enjoy the same protection if there's participation in the professional context and the work life is impacted.
Okay, so it sounds like quite a broad definition, and interestingly, the inclusion of the kind of intellectual and sensory impairment, which is something I haven't come across before. So what does it mean in practice then? So if you've got someone who is disabled, what kind of obligations does the employer have?
So this means that employers may not treat a worker who's neurodiverse more unfavorably than a worker who is not, without an objective justification that is determined by law, because this would constitute a direct discrimination. Indirect discrimination is also prohibited, meaning that neurodiverse workers may also not be indirectly disadvantaged as opposed to people who are not neurodiverse by measures that appear neutral at first sight.
Okay. So when employers come to us for advice, they are looking for practical guidance, so asking what they can do to assist neurodivergent staff, and also looking obviously to protect the business against potential claims. So part of this, we find that employers are now looking at neurodiversity as part of their DE&I policies. And we all know that there are studies out there that shows that this inclusivity makes people feel much more comfortable at work, it makes them more productive and more likely to stay. So turning back to you, Mandy, do you have some top tips for organisations and how they can build a more inclusive and neurodiverse workplace?
And I would agree with you that I think we're seeing many more organisations looking at neurodiversity as part of wider DE&I strategy and policies. I think the starting place really it begins, like many things in employment law, with awareness training. And that should be delivered at all levels of the organisation, you know, so from senior leadership really down. If senior leadership are championing neurodiversity, that's sending a positive signal, both internally for the organisation, but also externally too. And really, it's through training that staff can become more comfortable about how to talk about neurodiversity, about thinking about their own experiences at work, about areas where they might struggle at work and where they might be looking for support, and also crucially in enabling them to understand how to support colleagues who might need help, and taking away that sort of stigma or uncomfortableness about how to approach issues and how to support people at work. Obviously from a management perspective, so in terms of management training, I think neurodiversity training is of course important, and also understanding the potential areas of risk. So understanding where there are potential discrimination risks, understanding how to mitigate against those risks, for example, in terms of reasonable adjustments and how to deal with requests for reasonable adjustments. That's all obviously really important. And so I would say the starting point, it really is awareness training. And there are, of course, more practical steps that can be taken too, you know, so looking at the physical environment and trying to identify where within the physical environment there are elements that might cause difficulty for individuals with certain types of conditions. So common examples that we see or have seen coming up are things like office lighting. If you've got really bright lights, office lighting might contribute to sensory overload. Same as noise. So many of us now work in open plan offices. Sam and I were just talking before the podcast about hot desking and open plan, and that can create difficulties for people who might find a noisy working environment to be difficult from a sensory perspective. So looking at, you know, are there individuals who need quieter areas of the office? Can you allow use of headphones? Can you allow use of earplugs? Looking at how you deliver instructions to carry out work. So can instructions be delivered in a clearer, more precise way? Can they be made in writing rather than just verbally? Providing support and mentoring programs for employees. So that's obviously important across a range of different types of organisation and employees at different stages in their career. But if you have individuals who are potentially struggling in the workplace or who need additional support in the workplace, then some kind of buddying or mentoring programme might well be helpful. And also another area where I've seen a lot of queries arising recently is in relation to recruitment. So you want to really be looking at recruitment practices and thinking about, is there anything that we're doing here that is creating a barrier to people joining this organisation from the very, very outset? So, you know, what do your job adverts look like? Are they easy to read? Are they easy to understand? Do you provide applications in different types of accessible format? Do you accept applications in different types of way? You know, do they have to be completed online, or are there other ways in which applications can be submitted? And obviously, if people ask for support during the recruitment process, then ensuring that managers and those involved in the process are aware of how to provide that support and what support is needed. And obviously also in terms of conducting interviews. So I always think unconscious bias training so important for anybody who is involved in conducting interviews, in terms of recognising their own unconscious bias, also training on how to ask questions. And I suppose more fundamentally, thinking about that assessment process. Does it need to be through interview, or are there other ways in which candidates can be assessed and their potential suitability can be assessed? So those are just some examples. It's a bit like when we get questions about reasonable adjustments, what is a reasonable adjustment? In theory, could be anything, but those are some of the kind of most common examples that I've seen arising recently.
I think the recruitment point's really interesting because that's obviously the start of the journey in the workplace, and you're looking at attracting that talent. And I know that there are charities and foundations out there that specialise in kind of supporting the neurodiverse demographics. So it's a good place for employers to start if they want to take some advice from them. And the job descriptions about sort of including some visual aspects to them as well, and not just being all about words, and just the kind of, as you said, the policies around reasonable adjustments to the process. And just kind of looking at things from a slightly different angle. So looking back at Belgium and coming back to you, Kato, so a slightly different question. How important is it for employers in Belgium to be taking an active stance in preventing discrimination against neurodivergent staff? So what sort of preventative measures can they put in place to ensure that staff are treated fairly and equitably?
Well, very similar actually as what Mandy just described. So also under Belgian law, obviously direct and indirect discrimination is prohibited, like I said, but the employer also has the obligation to provide reasonable adjustments for employees with disabilities. So if they really want to be preventing any type of discrimination and really promoting inclusivity and making sure that neurodiverse people find their way to the workplace, they can make sure, for instance, that, as Mandy also described, that, for instance, solicitation or application tests are not necessarily required if they are not necessary for the role, or maybe amend them a little bit so that when they do have to complete a test, it is done in a room where the lighting is adjusted, far away from sound stimuli, so that they are less distracted, for instance. Another point could be that for a neurodiverse employee who has to formulate remarks on a certain test, if they have to do that verbally, that might be more difficult. And so a reasonable adjustment could be to give them, let's say, a delay of one working day to formulate their remarks in writing. So not every adjustment or accommodation is mandatory on the part of the employer. The criterion is always, is it reasonable or not? And to assess whether a measure is possible, factors considered include the financial impact of the adjustment, the organizational impact, the impact on the environment and on other employees. And in any case, the various regions in Belgium are trying to meet any additional costs of organizing or providing on-the-job support for workers with disabilities. So there are certain premiums that compensate part of the salary costs of disabled employees, which could also help for employers to actually accommodate and actually make reasonable adjustments. And all of this combined is then put together to assess what is reasonable and what isn't.
Thanks. And finally, when we look at the risk factors for business, obviously the worst case scenario is that employers are going to be faced with claims. And with successful discrimination cases in England and Wales, the employee can often look to obtain a declaration or recommendations from a tribunal that are more focused on the compensation, and we have different bands depending on the severity. Kato, I'm interested to understand from you the position in Belgium as a kind of contrast and what sanctions are available there against employers.
Well, I think that is a bit different as opposed to the UK. So in Belgium, of course, discrimination is also a criminal offence, so criminal sanctions can be imposed. And when it comes to civil claims, first and foremost, a victim could ask a cease and desist order in court if the discrimination is still ongoing. And then afterwards, let's say that, for instance, a neurodiverse employee has been terminated because of their disability, then they could claim compensation for discrimination, but that compensation is capped at 6 months' salary. So I think that's very different from the UK, unless the victim is able to provide proof of actual damages sustained. But that really rarely happens in court. So it's more or less 6 months. Now, we've had recent changes in law where multiple discriminations can be combined. So if, for instance, you have several protected criteria, then you could ask for 2 or 3 times. And now I actually have one case where an employee claims 6 times the 6 month salary. So it is starting to develop a little bit in Belgium, and higher damages are being awarded gradually. But overall, it's capped, which I think is very different from the UK.
Thanks. I think we'd sort of say there's some really interesting points who have arisen out of today's discussions, but overall that designing this truly inclusive workplace can produce real benefits for businesses, and there just needs to be more of a shift in the mindset and sort of tackling some of those adjustments which are probably easier to make in practice than an employer might think. If any of our listeners have any comments or questions on this subject, please do get in touch with your Meritas contact firm. We'd certainly be happy to continue the discussion. Or if you would like to find out more about Meritas, you can do so via the website meritas.org. And that just leaves me to thank Mandy and Kato for joining me today, and we hope you'll tune in next time. Thank you.